Hi, my name is Sharmin Anwer. I'm an attorney with Cobb Legal Aid, and I run Cobb Legal Aid's Lawyer in the Law Library program, which is housed in Cobb Superior Court's Law Library. I provide free 30-minute consultations to qualifying individuals on qualifying matters every Monday through Wednesday from 9 a.m. to 4 p.m. Consultations are available on a walk-in basis or can be booked online. And today I will be giving a presentation on the basics of the Equitable Caregiver Act. Just a little background about Legal Aid before we jump into the topic. Legal Aid is a nonprofit law firm that provides free legal services, again, to qualifying individuals on qualifying matters. We assist on a number of civil issues. You can call us if you are being evicted, if your landlord is refusing to make repairs, if you're experiencing domestic violence, if your disabled child's educational needs are not being met, or if your public benefits were terminated. If you'd like to open an intake with Cobb Legal Aid does intake and screening by phone, 9 a.m. to 12 p.m., Monday through Thursday. You can also submit an online intake for non-urgent issues. Just a disclaimer, this is a general presentation on Georgia law, and it may or may not directly apply to the facts of your case. Therefore, if you would like specific legal advice, please consult with an attorney for your individual case. As a reminder, you can seek individual assessment with Cobb Legal Aid if you qualify, or you can you could get specific advice through the Cobb Lawyer in the Law Library program if you qualify. So as I'd mentioned, we are going to be talking about the Equitable Caregiver Act in Georgia, which was passed in 2019. The Equitable Caregiver Act essentially allows third parties to establish custody and visitation without terminating parental rights. So it essentially gives them some sort of legal status and connection to that child while maintaining the biological parent's rights to that child. And the statute details the procedures and factors that the court considers in making their decision about whether or not someone can become an equitable caregiver. And it also establishes a clear and convincing standard in order to establish that equitable caregiver standing. It's important because this act essentially allows someone who has been taking care of a child or children in a consistent and permanent manner to apply for child custody and establish that kind of legal connection. It's also important to ask, why would one even petition for equitable caregiver standing? Well, there's a number of reasons. The first being stability for the child. So this act helps ensure that the child has stable, consistent relationship with an important figure in their life. There could be situations where a third party is taking care of that child in a parental-like manner, but because there's no legal connection or legal authority allowing that, that child could be taken away at any time. So this Equitable Caregivers Act essentially establishes that legal connection so that there is that stability. It also recognizes the caregiver's role as a vital role to the child, which is also very important. So again, it kind of recognizes it and gives a name to it, an authority to it that is recognized by law. It also allows for flexibility for the court. So the act gives judges more flexibility in making decisions in the child's best interest. So whenever we are talking about child custody, child visitation issues, the standard is always the best interest of the child. So the court will always ask, what is in the best interest of this child? And this statute essentially allows for more flexibility in that analysis. And it provides benefit to extended family members. So again, there are situations where extended family members are the primary caregivers to those children, and it benefits them because it will, again, give them that legal authority and give a name to that relationship. So the Equitable Caregiver Act provides the process in which someone would apply for that and get that standing. So the first step is to file the initial pleading along with an affidavit, which is under oath, And that affidavit and those pleadings would essentially include facts that support the existence of an equitable caregiver relationship that is actually required by the statute. So it's going to ask the petitioner to essentially provide substantial evidence that a parental-like relationship exists between the person seeking equitable caregiver standing and the child or children. Once that initial pleading and affidavit has been filed, it must be served onto the parents, any interested parties, any legal guardian of those children, or any adverse parties. And service is simply the process by which the interested parties are notified of this pleading, of this action, so that they may be involved in that process. And then they will also file a response to those pleadings, along with an affidavit to support their response. The court may decide to hold a hearing to determine facts that are material to the issue of standing, and we'll talk a little bit more about standing in a minute. But if this is met, then the third party seeking equitable caregiver standing may proceed to the next step. But essentially, you're trying to show the court that you have been providing consistent, stable care of the child in a permanent manner, and that you're really acting as a parent without legal standing. You're not acting so much as just an aunt or an uncle, but really as a parent to that child. So as I mentioned, we'll talk a little bit more about what standing is. So the statute says that in order to establish standing, the court must first find that the individual seeking equitable caregiver has a number of things met. So need to show that they have fully and competently undertaken a permanent, unequivocal, committed, and responsible parental role in the child's life. Again, this is different from the role of an aunt or uncle or grandma or grandparent. The idea is that this person really does play the role of a parent, and it's consistent, it is clear, it is not something that is done unwillingly or by force. It's something that is done to provide stability for the child. So that needs to be shown in order to show standing. The person also needs to have engaged in consistent caretaking of the child. It can't be something that is very wishy-washy or inconsistent. Need to also show that there's established a bonded and dependent relationship with the child, which relationship was fostered or supported by a parent of the child, and such individual and the parent have understood, acknowledged, or accepted that or behaved as though such individual is the parent of the child. Again, not acting as a grandparent, not acting as an aunt or an uncle, but truly that this child is theirs in a way and that they're acting as a parent to that child. And they need to have accepted full and permanent responsibilities as a parent of the child without really any expectation of financial compensation. So again, this isn't something that is established through some kind of unwillingness or inconsistency, or you're being paid essentially to take care of this child. You're really doing it because you are taking care of that child in a parental-like manner. And then you'd also need to demonstrate that the child will suffer physical harm or long-term emotional harm, and that continuing the relationship between such individual and the child is in the best interest of the child. Again, we're seeing that standard that the courts look at when determining child custody and visitation, which is best interest of the child. So let's talk a little bit about harm. I just mentioned that there would be harm to that child if that relationship is not established. So when we're looking at whether there's harm, we're looking at who are the past and present caretakers of the child. Who has been in this child's life? How long has that person been in that child's life? Is the person seeking equitable caregiver status someone who's been in that child's life from the very beginning? Is it someone who's only been there very recently? So that's important because arguably the length of time that has been used to establish a relationship with that child is important. And the longer that relationship has been, the more harmful it could be if they're not given that status. We also look at who has a child formed psychological bonds with and the strength of those bonds. So is this really something where you look at the child, do they really have a close bonded relationship with the person seeking that status? Also looking at whether the competing parties evidence an interest in and contact with the child over time. So again, we're looking at how long has this person been in this child's life? How much contact has this person had in this child's life? That goes to issues of consistency and stability. Is this someone who has only recently made contact, or is this person who makes contact very infrequently over the child's lifetime? And then also looking at whether the child has unique medical or psychological needs that one party is better able to meet. So those are the factors that the court looks at to see whether there would be harm to the child. Now, you can also have standing based on consent. So the statute states that the court can grant the equitable caregiver standing if one of the child's parents consent, and the equitable caregiver essentially consents to that, or a written agreement to share divide parenting responsibilities. If a biological parent has not consented to the caregiver action, then obviously the process would be a bit more difficult than if there was consent present. Unless the parent is unfit to care for the child, the court will generally consider them as the caregivers. And again, this act does not terminate the parental rights of the biological parents. That's important to note because other arrangements can terminate it, and that's obviously very drastic. Having a parent's rights terminated is very, very drastic, but the statute does not do that. Some other considerations when we're talking about equitable caregiver standing. The statute does not allow a caregiver action when the child is living with both parents who are not separated. Again, that doesn't really fall in line with the factors we see in equitable caregiver standing, where there's consistency and permanency and stability. So if the child is living with the parents who are not separated, it's unlikely that an equitable caregiver standing would be given or adjudicated. The statute does not allow an original action so long as the Division of Family and Children Services of the Department of Human Services has an open child welfare and youth services case involving such child or his parent. So essentially, if maybe the reason why the child is placed with the person seeking equitable caregiver standing is because of a defects proceeding, it's unlikely that they would be granted that equitable caregiver standing. An order of equitable caregiver does not establish the parentage of any other parent, so that's also important to consider. So we've talked about what the Equitable Caregiver Act is and what it does, what the process is, what one needs to show in order to be adjudicated an equitable caregiver. But it's also important to take a few minutes to look at other options. So what else might exist other than an equitable caregiver standing? So some other options, this is not an exhaustive list, just some other common options, alternatives is grandparent visitation, standby guardianship, temporary guardianship, and dependency action. And we'll briefly go over each of these. Grandparent visitation is talked about in OCGA section 19-7-3, and visitation, this part essentially says that visitation rights are granted if the court finds child would be harmed unless visitation is granted, and it would be in the child's best interest. Again, we're seeing that standard again when we're talking about visitation and custody. And again, this is for grandparent visitation. And grandparents can intervene in any court action involving a minor child's custody. So that's divorce proceedings. It could be proceedings to terminate a parent's rights. So you could imagine a situation where maybe two parents are going through a divorce, and if they have minor children involved, the court will necessarily have them go through a parenting plan and custody in which they will have to detail who has primary custody, what does that parenting plan look like, what does the visitation schedule look like. So if grandparents want to ensure that they have that connection remaining even after a divorce and that the divorce doesn't affect it, they can petition for grandparent visitation in that divorce case. Similarly, if there is no divorce present, but maybe there's a custody issue going on in a legitimation case, grandparents can also petition in that as well. The other option is standby guardianship. So we're talking about this mostly in emergency situations related to the health of a parent or guardian. So healthcare professionals would have to certify that the parent or guardian is unable to care for the child. And this document must be filed in probate court in the county where the child resides, and it's automatically going to be terminated after 120 days. So this is, again, standby guardian could be, it's more of an emergency type situation, and it's not meant to be a long-term solution to anything. Next is temporary guardianship. This is something we see pretty commonly. See a lot of people trying to petition for temporary guardianship. This can be useful in situations where a parent needs to place their child with a relative or friend just for a temporary amount of time. You can imagine a situation where maybe one parent is in the military and will be overseas for a while, so they don't want to uproot that child or cannot uproot that child, and so they grant temporary guardianship to a loved one, a family member, someone who could have that child and have that legal authority. So the idea is that the parents or the parent is not able to care for that child just on a temporary basis. In order to get a temporary guardianship, you would have to file a petition for temporary guardianship in the probate county of the county where the minor resides, and must also have physical custody of the minor at the time of filing. Again, parents can consent to this, which makes things a lot easier. This is also something we see sometimes people petitioning for when a parent becomes absent. But the idea with the temporary guardianship is that the child will return to the parent at some point. The power of a guardian over the minor is the same as that of a parent over a child. So if an adult has temporary guardianship of a child, they have the right to enroll that child in school, obtain medical treatment for that child, obtain housing for the child, and otherwise make decisions for the child. The last option that we'll be talking about is dependency action. This is really best when the parents are not capable of caring for the child, where parents will not consent or will object to the guardianship. Again, parents are absent, the child needs services. The plan is for the child to return the parents' care only if the parents are capable of caring for the child. So this is really a little bit different, and it's, again, we're looking at a situation where maybe they're not capable of taking care of the child. But these are just a few alternatives to the Equitable Caregiver Act. There are other options out there. I hope that this information is helpful for you. If you have questions, you can always contact Cobb Legal Aid. Again, we take intake and screening Monday through Wednesday from 9 a.m. to 12 p.m. Again, for non-urgent issues, you could submit an online intake, and if you are hoping to speak to an attorney and see if you qualify, you can come by the law library and possibly receive a free consultation with me. Thank you so much.